Okay. On each of the jurors' chairs. Okay. And then, okay, Mr. Lawler, if you just get your client and the rest of anyone else who wants to be here. Okay, just before we proceed, we have a new cameraman here today. Sir, do you intend to film the jury? No. Thank you, sir. Okay, is the state ready to proceed? Defense ready?
Yes, Your Honor.
Okay, let's bring the jury in. Also, just want to remind everyone to shut off your cell phones or other electronic devices so they don't interfere with the closing arguments. Thank you.
Jurors are entering.
All right, welcome back, everyone. You may be seated. Members of the jury, thank you very much for your patience with us this morning. I can assure you that we've been working here in the courtroom since 8:30 this morning, and it took us a little bit longer than I anticipated yesterday to discuss some legal matters that we needed to address before the attorney's closing arguments. But we have finished those now, and again, I apologize for the delay, and I appreciate your patience with us. As I indicated when you left the courtroom yesterday, both the state and the defense have rested their cases. The attorneys will now present their final closing arguments to you. Please remember that what the attorneys say is not the evidence, and it is not your instruction on the law. All right. The evidence came to you from the testimony of the witnesses and the other items that were marked as exhibits during the trial. The instructions on the law will come from me. I have provided the attorneys with a set of instructions, and I've provided each of you with a set of instructions. The attorneys will deliver their closing arguments, and then I will read the instructions to you. I would ask, however, that you pay attention to the attorney's closing arguments very carefully because they are intended to aid you in understanding each side's case, okay? Each side has equal time to present argument to you, but the state is entitled to divide up its time. So you will first hear closing argument from the state. You will then hear closing argument from the defense. You will then hear rebuttal argument from the state. Okay. Within those arguments, several attorneys may be arguing to you. It's my understanding that from the state side, Ms. Fallon and Mr. Williams will present argument to you, and from the defense side, Mr. Lawler and Mr. Smith will present arguments to you. Okay, I've allowed them to do that. I have given you a copy of the instructions. At this point, I've given those to you in case the attorneys want to refer you to any particular passage in the instructions. You don't need to pay particular attention to them right now. I would ask that you pay attention to the attorneys, but if they direct you to a particular element or passage of the instructions, that's why I've given them to you. You will be permitted to bring those instructions into the jury room with you when we reach the deliberations portion of the trial, as well as your notepads, and then they'll be collected back from you at the end of the trial. Okay? State, you may proceed with your closing argument.
Thank you.
And just before we do that, does everyone have a working pen and enough paper as far as the jurors go? Okay, thank you.
Good morning. I want to thank you for your time and attention. In opening statement, I told you that this case is going to be like a puzzle. And I also told you that over the course of the week, you are going to get all the pieces to that puzzle. At this point, you have all the pieces but one, the law. And that's what you have in this packet sitting in your lap. And it's the judge's job to instruct you on the law. And this is going to be your final piece. And what I'm going to do is I'm going to go through this with you. And I'm going to put the pieces together. I'm going to show you where they go. I'm going to take the facts, which is all the testimony, the photos, the videos you've seen, apply them to the law. And when you take the facts and you apply them to the law as the judge instructs you, you're going to get a verdict. I'm going to start a little bit backwards with count 3. And if you want to follow along with me, that's on page 2. Count 3 is the battery count. And I'm starting here because this is the count that gets everything started. This is where it all begins. This is what brings us here today. And to prove the crime of battery, the state must prove the following element, just one, beyond a reasonable doubt. And that one element is not the defendant, Noel Carter, intentionally touched or struck Joanna Espejo against her will. So let's talk about that. What pieces do we have? What evidence have you heard over the course of this trial to establish that Noel Carter intentionally touched or struck Joanna Espejo against her will? I submit to you, members of the jury, that the evidence is overwhelming. And I'm going to break it down. We're going to start with that Noel Carter intentionally touched or struck Joanna Espejo. So what does that mean? That means that he touched her. You heard from 3 people, 3 witnesses, who told you that they saw the defendant touch Joanna Espejo. And you even heard from the defendant himself, who sat right there and told you that he too touched Joanna Espejo on the corner of Orange and Concord in front of that trophy shop. Let's talk about what they said. You had Vaughn Daly, who was doing his job, security officer at the club, sees the defendant follow Miss Espejo out of the club, walk down the street about a block away, and what does he tell you? He tells you that he sees an argument, a disagreement. And how does he know it was an argument? Because he's seen a lot of arguments. He's seen a lot of disagreements. He's a security guard at a nightclub in downtown Orlando. It's common sense. He knew. It was clear to him what was going on. And then he saw the defendant grab Mrs. Spejo's arms aggressively while they're arguing, to the point that Mrs. Spejo pushes him off of her. That's not the only witness we heard from. We also heard from Paul Thomas, another security officer working that night at Vending by 7. Another individual who sees altercation in his line of work all the time, he said. He sees stuff like this all the time. And he saw the defendant grab and shake Mrs. Spejo aggressively. And then you have Officer Cruz, who, after being alerted by Von Daly, gets out of his car and sees the defendant pulling on Mrs. Spejo's arm as she's trying to get away from him. So that brings us to the next part, that it was against her will. How do we know that? In jury selection, there was some discussion about circumstantial evidence, and there was a hypothetical that if someone's in a suit, behind a bar, in a courtroom, at counsel table, that you can infer that they're wearing shoes. That those facts and circumstances provide you with the inference that someone in a suit, at counsel table, presumably a lawyer, in a courtroom, would be wearing shoes. That's reasonable to assume that. So that's what we have here. We have facts that when looked at reasonably, give you the inference that it was against her will. And it doesn't start at the corner. It starts inside the club. When Mr. Carter himself told you that he was persistent, that he wanted to talk to Joanna Spejo about why this other guy had come to a concert with them when he had come all the way up from Miami to spend time with his ex-girlfriend. Now, he says that it made him uncomfortable. I submit to you that it made him angry, that it made him jealous, that he was upset. And he had a few drinks, and he wasn't happy that when they were at dinner, Joanna Spejo referred to him as her banker. He didn't like that. He didn't want to be her banker. He wanted to be her boyfriend. And he didn't like this Javante Whitfield guy getting in the way of his woman, getting in his way. So he continues to try and talk to Joanne about what's going on, about why Travante's there, about what their relationship is. And what did he tell you? She didn't want to have the conversation. She didn't want to have it. She didn't want to talk to him. So what does she do? She leaves the club. And we're going to look at that video. Because members of the jury, not only do you have the witness testimony that the defendant followed Mrs. Spejo out of the club, you don't even have to take their word for it because there's video of it. all of the witnesses that saw Mrs. Bayo leave the club said that she looked upset. Andrew Taylor, the first witness, here she is coming out by herself. And now the defendant, more than a few steps behind her, is following her out. She doesn't pause. She doesn't look behind her. She doesn't wait for him. Because she's not going outside so that they can have a conversation. I submit to you that she's going outside so that she can get away from him. And he's following her out. Because if they were going outside to have a conversation together and she had asked him to come outside, it would be reasonable for her to wait for him, to look behind her, to make sure that he's coming. But that's not what we see here. You see her exiting and him following behind her. In fact, the witnesses told you he had to go at almost a jog to catch up to her. Andrew Taylor told you that when she walked out, she looked like she wasn't having a very good time. You know why? Because she wanted the defendant to leave her alone, and he wouldn't. Because Mr. Carter wouldn't say no for an answer. Look how far apart they are. She's not stopping. She's not waiting. She's not looking behind her to make sure he's coming with her. She's trying to get away from him. To the point that he has to pick up a step to catch up to her. And he does, in front of the trophy shop. And an argument ensues. And when she again tells him, "I don't want to have this conversation with you," he grabs her. He shakes her. As she tries to walk away from him, to get away from him, he pulls her back towards him. I submit to you that all of those facts provide you with only one inference: that he touched her against her will. And it doesn't have to be a violent touching. He doesn't have to cause any injury. It could be any touching. It could be a caressing of the arm, like the judge, like the defendant described it. It doesn't matter. If Mrs. Bayo didn't want him to touch her, it's unlawful. And I submit to you, members of the jury, that based on what we've heard throughout the course of this trial, based on the testimony of the witnesses and this video, she did not want to talk to him. She wanted him to leave her alone. And that's what she told Officer Cruz. Crying, upset, barely able to get her words out. "I just want him to leave me alone." Now, the next count I'm going to talk to you about is count 4. It's on the same page, it's right below the battery count. So, battery, check. We have one element, Noel Carter, touched Joanne Bayo, and it was against her will. The evidence supports that. You can check that off. Count 4, resisting an officer without violence. The judge is going to tell you that to prove the crime of resisting an officer without violence, the state must prove all of the following 4 elements beyond a reasonable doubt. So we're going to break them down. So we're going to start with element 1. That Noel Carter resisted, obstructed, or opposed David Cruz or Charles Mays. So what do we have to show that? I submit to you, members of the jury, that throughout the entire interaction between Officer Cruz and David Mays, the defendant resisted, obstructed, or opposed both of them. But what's the first incident we have? It's when Officer Cruz asks Mrs. Bayo and the defendant to come to the side of the the defendant grabbing Mrs. Spejo as she's trying to get away. Officer Cruz told you that he went and spoke to Mrs. Spejo, who told him that she just wanted him to leave her alone. So she was going to find another way to go. Officer Cruz walks over to Mr. Carter, and Mr. Carter is non-responsive. He's not even acknowledging Officer Cruz's presence. He's fixated. He's focused. He's determined to get to Mrs. Spejo. Because no one is going to tell him no that night. Not Mrs. Spejo, not Officer Cruz, and not Officer Mays. Officer Cruz tells you he even has to wave his hand in front of the defendant's face to get his attention. And you don't even have to take Officer Cruz's word for that, because that first witness, that patron who just went to the club to also watch the Trinity concert, he saw it too. And he sat there and he told you that the defendant was non-responsive, wasn't paying attention, had a blank stare. Officer Cruz waves his hand in front of his face. No response. Still looking at Mrs. Spejo. Determined. Fixated. One thing on his mind. So Officer Cruz, realizing that the defendant appears to still want to go over and talk to her, tells him, hey man, you can't talk to her. Why don't you just leave? Why don't you just leave? But the defendant wasn't going to be told no. What does he do? He says, I want to talk to her. Officer Cruz again gives him another opportunity. You can't talk to her. What does the defendant do now? He says, I'm going to talk to her and you're not going to stop me. And he begins to walk towards Mrs. Spejo. Second element is that at the time that the defendant resisted, obstructed, or opposed David Cruz or Charles Mays, that David Cruz or Charles Mays was engaged in the lawful execution of a legal duty. And we're going to spend some time here on this element. And there's going to be some instruction that tells you what a lawful execution of a legal duty is. It tells you that, and this is on page 30 at the top, an investigation by an officer is the lawful execution of a legal duty. It also tells you the protection of the public or persons is the lawful execution of a legal duty. Officer Cruz told you he was concerned for Ms. Espejo's safety. The defendant wasn't listening. He wasn't taking his orders. He wasn't leaving. And Mrs. Espejo had clearly told him that she wanted the defendant to leave her alone. This is what Officer Cruz knows at the time. Mrs. Espejo wants the defendant to leave her alone. He's seen the defendant grab her and try to pull her back to him. He sees the defendant is non-responsive, focused on Mrs. Spejo, continually wants to try to walk towards Mrs. Spejo despite being told no. Officer Cruz has a legal duty to protect Mrs. Spejo. That is his job. That is his legal duty. And when he tells the defendant, no, you can't talk to her, and the defendant says to him, I'm going to talk to her and you're not going to stop me, members of the jury, that is resisting without violence. That is resisting without violence. That initial interaction where Officer Cruz is protecting Mrs. Spejo from the defendant trying to go to her and talk to her, and the defendant ignoring Officer Cruz's lawful commands that he can't speak to her, that he needs to leave, that he can't go over there. The defendant is resisting, obstructing, opposing Officer Cruz. The third element is at the time Officer Cruz or Charles Mays was an officer. That's clear. check that off. There's been no argument. They were officers. The court will tell you that every law enforcement officer for the city of Orlando is an officer for the meaning of the law. The defendant told you he knew they were officers. No question. Check. No dispute on that. 4, at the time, Noel Carter knew David Cruz and Charles Mays was an officer. He told you he knew. No question. No argument. No dispute. I anticipate the dispute is going to be in element 2. That Officer Cruz and Officer Mays were not engaged in the unlawful execution of a legal duty. But that's not what the facts support. Because the facts show you that Officer Cruz was concerned for Mrs. Bango for safety. And he had a lawful duty to keep Mr. Carter away from Mrs. Bango. And when Mr. Carter told him he wasn't going to do that, that's resisting without violence. I submit to you that the defendant continued to resist without violence throughout the whole interaction, as Officer Cruz and Officer Mays continued to give him verbal commands: put your hands behind your back, get on the ground, stop resisting. And the defendant, time and time again, throughout the entire interaction, ignored their commands, did not comply with getting on the ground, did not put his hands behind his back. He did not listen to any of the officer's commands. Because he wasn't going to be told no for an answer that night. Next, we're going to go to resisting an officer with violence on page 1. Similarly to resisting an officer without violence, there are 4 elements. And really the only difference here is in element 1. That Noel Carter knowingly and willfully resisted, obstructed, or opposed David Cruz or Charles Mays by offering to do or doing violence to him, to Officer Cruz or Officer Mays. So the only difference between count 4, resisting without, and count 1, resisting with, is that the defendant resisted, obstructed, or opposed by offering to do violence or by actually doing violence. So what do the facts support in this case? Well, you heard from Andrew Taylor that the defendant was able to get away from Officer Cruz's bear hug, that he lunged at Officer Cruz when Officer Cruz attempted to dry stun him. You heard Officer Cruz tell you that when he went to get close to the defendant turned around and lunged at him, knocking his taser out of his hand. There was the jury, that is violence. That is doing violence to Officer Cruz in an effort to resist, obstruct, or oppose. But it doesn't stop there. Because then, when we get down Orange Avenue after the defendant's blood from Officer Cruz and Officer Mays and sits on the corner, Officer Mays tells you that as he's trying to pull the defendant off of Officer Cruz, who he now has pinned to the ground, which I submit to you is also offering or doing violence to Officer Cruz, he punches Officer Mays in the chest. Close fist. That's violence. That is resisting an officer with violence. Lunging at Officer Cruz, disarming him on the side of the venue, pulling, pushing, tearing away from all Officer Cruz's attempts to restrain him, and most importantly, punching Officer Mays in the chest. These are all resisting with violence. So, check that off. Number 1, you got it. Number 2 is the same as resisting without. At the time, David Cruz or Charles Mays was engaged in the lawful execution of a legal duty. And we talked about that. They have a duty to protect the public. They have a duty to keep people safe. So not only do you have the legal duty that they're protecting the public, but at the time he resists with violence, they're also executing, or attempting to, the legal duty of an arrest, because he's already committed the crime of resisting without violence. When he doesn't leave, when he keeps walking towards Mrs. Fayho when he's told he cannot. So, I submit to you, members of the jury, you can check that right off. Number 3 and number 4 are what we talked about earlier. The law tells you, or like a police officer is an officer within the meaning of the law. Check the problem. Number 4 is that Noel Carter, the defendant, knew they were officers. He told you he knew. There's no dispute over that. There's no question. Check. So now we come to our final count. Count 2. Battery on a law enforcement officer. To prove the crime of battery on a law enforcement officer, the state must prove 4 elements beyond a reasonable doubt. 1. Noel Carter intentionally touched or struck David Cruz or Charles Mays against his will, or caused bodily harm to David Cruz or Charles Mays. It's not both, it's one or the other. Just has to touch or strike them against their will. It's just like the battery instruction for Mrs. Fayho. What evidence do we have to support that? We have the defendant lunging at Officer Cruz, knocking his taser out of his hand. A taser that is attached to Officer Cruz's body to the point that it is part of Officer Cruz's body. He knocks it out of his hand. It's battery. Then the defendant takes flight down Orange Avenue. He's on the corner. Officer Mays is trying to get him off of Officer Cruz, and what does he do? He punches Officer Mays in the chest. He intentionally touches or strikes Officer Mays against his will. Officer Mays told you he didn't give the defendant permission to touch him. And he's going to have to tell you that because just like Mrs. Fayho, the facts and circumstances can give you that. The facts give you the inference that they did not give Mr. Carter permission to touch them against their will. And you only have to find that he committed a battery against one of these officers. So even if you don't think that the lunging at Officer Cruz and knocking his taser out of his hand is sufficient for a battery, when he goes down Orange Avenue and he sits on the sidewalk and he punches Officer Mays in the chest, he's intentionally touching or striking Officer Mays against his will. You only have to find one. You don't have to find both. It's 4. Second element, same as all the others, that they were a law enforcement officer, check, no issue. Third element, that Noel Carter knew they were law enforcement officers, no issue, check, he told you. There's no dispute there. The fourth element is that David Cruz or Charles Mays was engaged in the lawful performance of his legal duties when the battery was committed. Now, this is a little different than the element we have in resisting an officer without violence and resisting an officer with violence. Because it tells you that they have to be engaged in the lawful performance of their duties. So they have to be on duty. They have to be working in their uniform as a police officer. And they have to be performing their duties lawfully. I submit to you that working at venue 578 as an off-duty police officer is within their lawful duties. Investigating a possible crime is within their lawful duties. And most importantly, protecting members of the public is within their lawful duties. They were acting lawfully. They were working that night lawfully. When the defendant touched and struck them against their will, both of them. Now you're also going to get some instructions. And we're going to talk about one pretty extensively because I anticipate that the defense is going to get up here and talk about it, and that's on page 3, and it's justifiable use of non-deadly force. And I anticipate that they're going to stand before you, and they're going to say that the defendant was justified because the officers used excessive force. But that's not what the facts support. And we're going to talk about that. We're going to go through the instruction. And if you look at the 4th full paragraph, it talks about law enforcement officers specifically, and when you're justified in using non-deadly force. And it says a person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith or he or she is known or reasonably appears to be a law enforcement officer. So we've already established that they reasonably appear to be law enforcement officers. They're engaged in the execution of a legal duty. However, it does say if the officers use excessive force to make an arrest, then a person is justified in the use of reasonable force to defend himself. That word is important. Defend. Because that suggests that the excessive force came first. But that's not what we have here. We have actions by the defendant that resulted in a response from the law enforcement officers. The defendant's actions came first. And the law enforcement officers had to respond to that. The defendant was not defending himself against the officer's excessive force. The officers were adjusting their level of force as the defendant escalated his force, escalated his resistance. They told you they had to try everything in their tool belt. They had to evolve and change as the defendant continued to resist their efforts to restrain him. They had to use the force necessary to protect themselves, the public, and Mrs. Bayo. Mr. Carter was not defending himself. Mr. Carter was being aggressive. And that's what the witnesses told you. That's what Andrew Taylor told you. That's what Paul Thomas told you. And that's what the officers told you. And most importantly, that's what the video supports. You'll remember, Andrew Taylor was here. He told you to solve the altercation. The defendant was not listening to the officer's requests. The defendant was being aggressive. The officers were continually trying to get him under control. The defendant could not be stopped. And he took out his cell phone. Defending themselves. That is not someone turning around with both hands out. Please stop doing this to me. That is someone lunging at Officer Cruz in an aggressive manner. believe that the danger to Mr. Carter has to be so real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. I'm going to go over that again. So real that a reasonably cautious and prudent person under the same circumstances would have believed that the danger could be avoided only through the use of that force. Only. Then, Mr. Jury, you know how Mr. Carter could have avoided the use of that force? By putting his hands behind his back when he was first asked. But that wasn't the only opportunity Officer Cruz and Officer May gave him, because that video you just watched, you can hear them yelling at the defendant to get on the ground. They're not using any force. They're telling him, they're giving an opportunity to get on the ground. You know how he could have avoided that? He could have gone on the ground. But he didn't. Because Mr. Carter's actions were not defensive. They were not justified use of force. They were aggressive. And Officer Cruz and Officer May's actions were in response to that aggression. They did what they had to do to protect themselves and the public, and especially Ms. Feo, from Mr. Carter. Because what did they tell you? They didn't know Mr. Carter on June 4th, 2015. They didn't know if he had any weapons. They didn't have a chance to pat him down. All they knew was that he had an altercation with his ex-girlfriend. She wanted him to leave her alone, and he wasn't listening. In fact, he told him, "You're not going to stop me." That is not defensive, members of the jury. And I'm going to show you another video that gives you a better angle of that lunging towards Officer Cruz. General Manager, Mr. Padovano, is going to this side of Concord. This is the railing. This is where Officer Cruz first brings Mrs. Feo and the defendant over to speak to them. When he first begins to move towards her, you can see her, you can see everyone adjusting around her in an effort to protect her from him, just like they told you. Just like all the witnesses saw, Officer Cruz tries to take him to the ground. He gets right back up. He then walks away. There's the defendant. There's Officer Cruz. Officer Cruz goes to tase him, and he lunges towards him. He lunges towards him with one arm. Officer Cruz has to back away from him. there, and I want you to watch. Pay attention to the defendant's body and Officer Cruz's response. He walks towards Officer Cruz. That's not someone afraid. That's not someone scared. That's not someone that feels that that's the only way to stop the force. It's not reasonable. Another factor that you can take into consideration when determining whether the defendant's use of force is reasonable is the size of everyone involved, including the defendant. And the defendant described Officer Cruz and Officer Mays as out of shape and fat. But he was athletic. In fact, he is confident in his athletic ability. Someone that sizes up the officers and is able to determine that they're out of shape and fat, but that he is confident in his athletic ability, doesn't have a reasonable fear. He sized them up. He knew they were fat. He thought they were fat. He thought they were out of shape. And he thought he could defeat them. He definitely thought he could outrun them. And he was going to resist their efforts every way that he could. Because he wasn't going to take no for an answer. Not that night. And the next instruction should be read along with that instruction. They go together. Because it talks about justifiable use of force by a law enforcement officer. And this is really important. Because it tells you that a law enforcement officer or any person he or she has summoned or directed to assist him or her need not retreat from or stop efforts to make a lawful arrest because of resistance or threatened resistance to arrest. So what does that mean? If someone's resisting their efforts to arrest him, they don't have to give up. They don't have to say, oh, you're resisting, we stop. That would be unreasonable. I submit to you that would be dangerous. And the law tells you they don't have to do that. In fact, it goes on to tell you that they're justified in the use of any force, that he, the law enforcement officer, reasonably believes, so it's what the law enforcement officer, in that circumstance, in that situation, reasonably believes is necessary to defend himself or another from bodily harm while making the arrest. It tells you that force is also justified when necessarily used in arresting a suspect who is fleeing from justice. The officers are justified in this case. And the law tells you that they were justified. It tells you that they can use any force they reasonably believe necessary, based on the facts and circumstances known to them at that time. They don't have to give up. But they just let them go. No. They had to use force to protect not only themselves, but the public and Mrs. Specco. And they used only the force necessary. In fact, they told you, they tried everything. They started with verbal commands. That didn't work. They tried with just putting his hands behind his back. That didn't work. And all they were trying to do was get him under arrest, detain him, keep him away. But he wouldn't stop. In fact, he took him on a 100-yard chase down Orange Avenue. There was the jury. If he was in fear for his life, if he had a reasonable fear when he was on the corner of Concord and Orange, why don't we hear him asking for help in that video? Why don't we hear him saying, help me, help me? None of the witnesses heard him ask for help. Not just the law enforcement officers, but security officers that were working that night. Mr. Taylor, who was just there to see a concert. It's because he wasn't afraid of the jury. Because he didn't have a reasonable fear. He just wanted to get away because he wasn't going to be stopped. He wasn't going to be told no. And the officers don't have to just let him go. In fact, that would not be reasonable, and that would not be safe. And they did everything they could in their tool belt to restrain him. There's also an instruction that says use of any force by a law enforcement officer or any person summoned or directed to assist a law enforcement officer is not justified if the arrest or execution of a legal duty is unlawful and you have to have both. It is known by the officer or person assisting him to be unlawful. We talked about this. As soon as the defendant wouldn't leave and refused to listen to Officer Cruz, who told him he couldn't speak to Mrs. Bajo, he committed a crime. He resisted Officer Cruz's lawful commands. Officer Cruz and Officer Mays' attempts to arrest him after that were all lawful. The court's also going to give you some instruction on how you should weigh the evidence. It's going to tell you that it's up to you to decide what evidence is reliable. We talked about that. It's completely within your prerogative to pick and choose what you want to believe. You can believe some of what someone said and not all of it. You can believe one witness and not the other. That's completely up to you. But it also tells you that you should use your common sense in determining what's the best evidence. You don't have to leave that behind. You can use your common sense. For the jury, you heard Officer Cruz and Officer Mays give you detailed accounts of what happened that night. Specifically what happened on the curb. After the defendant had already resisted all of their efforts on the side of the club, and I submit to you had already committed all of the crimes one before. He then continues to flee, sits down, and the officers tell you what happened. And I submit to you that you use your common sense, and you rely on your memory of their testimony, and when you put their testimony against this video, it matches. It's consistent. What they say happened, and while this is grainy, and you have to look at it, and you're going to have all this, and I encourage you to watch all the videos. Watch them for the ones that you need to. Look at them closely. Analyze them. Compare what was said to what you see. And it matches up. It's consistent. Because that's what happened. Because all they were trying to do is get him into custody. And they told you everything they had to do was hurt in order to do that. And most importantly, once they got him in handcuffs, the force stopped. They didn't touch Mr. Carter. They didn't strike Mr. Carter. They didn't use any of their tools in their tool belt because that was their goal, to get him in handcuffs, to protect the public and themselves and Mrs. Bajo from Mr. Carter that night. And once they got that, once they were able to secure him, that was it. opportunity to see and know things about which the witnesses testified. The only one who had the opportunity to see and know what the witnesses testified to is the defendant, who's been sitting here the whole time. He got to see all of the witnesses testify. He got to see all of the evidence. He's the only one. That's something that you should consider. It's also going to tell you that you can consider does the witness have some interest in how the case should be decided. I submit to you that the defendant is the only one in this case that has any interest in how it should be decided. Because he doesn't want to get in trouble. Mr. Taylor has no interest in how this is decided. He just wanted to go to the club to see a concert. He didn't intend to have to come and sit and tell you what he saw that night. He doesn't care how this is decided. Mr. Daly, he definitely doesn't care how this is decided. He was just doing his job. Nobody told him what to say or what to do. He doesn't care what happens here. Mr. Thomas, the other security officer, also just doing his job that night. He doesn't care how this is decided either. The defendant has the biggest stake in this, biggest interest in this case. Because the defendant doesn't want to get in trouble. And you have to consider that when weighing his credibility and deciding whether you want to believe what he told you. Number 5, does the witness's testimony agree with the other testimony and other evidence? I submit to you that it does. You heard from 3 civilian witnesses who told you that the defendant was being aggressive. He wasn't listening. 2 of them saw him grab Mrs. Fayeho. Then you have 2 officers whose accounts of the event are also similar, who also match up, that fit the video. What they said fits the video. You don't even have to take their word for it, members of the jury, because there's video that shows you what happened. It shows the defendant being aggressive, not defensive, aggressive, resisting, obstructing, opposing. The judge is also going to tell you, and I think this is really important, it is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. Entirely proper. It's completely okay. And it goes on to tell you, they should not be discredited by talking to a lawyer about his or her testimony. It's completely okay. Expected. There's some rules for deliberation as well. I won't go through all of them. I'm only going to touch on the important ones. They're on page 6. It tells you that the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and seen in the form of exhibits and evidence. That's it. What the lawyers tell you isn't evidence. It's what the witnesses sat there and told you. It's what the video shows you and the pictures. That's it. That's what you're to base your decision on. It also tells you this case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. That's what's the law. Equal the verdict. That's it. Number 8, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must. The law tells you your verdict must be based on the evidence and the law contained in these instructions. That is it. It's telling you you must. When you take the facts and you apply them to the law, that's how you should get your verdict. And the facts that you heard from the witnesses and you saw on the videos, not what the attorneys tell you. In a few moments, I'm going to sit down, and Spence is going to have a chance to stand here and talk to you. And I expect that along with the justifiable use of force, they're also going to talk to you about reasonable doubt. And I'm going to ask that you listen carefully to what they say. And that you listen for words like could, should, maybe, possibly, might have, a spiteful doubt, a forced or imaginary doubt. In fact, it tells you such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. So possibly, maybe, could have, should have, might have been. That's not reasonable doubt. And that should not influence your verdict if you have an abiding conviction of guilt. If you have no reasonable doubt, the judge is going to tell you, you should find the defendant guilty. Members of the jury, I'm going to ask that you pay attention to all of the evidence that you heard and you saw, and you compare the testimony against each other, and you watch the videos as many times as you need to, and you listen to them. And you scrutinize them. And I'm confident that when you take the facts, the evidence, and you apply it to this law, that there is only one verdict that the law supports for each count. And that is to find the defendant, Noel Carter, guilty of resisting Officer Cruz or Officer Mays with violence, guilty of battery on a law enforcement officer for Officer Cruz or Officer Mays, guilty of battery against Joanna Spejo, and guilty of resisting an officer without violence. Thank you.
Thank you, Ms. Fallon. All right, members of the jury, we're going to take a short recess at this time. Please remember to leave your notepads on the chair as you exit. Please also remember not to discuss this case amongst yourselves or conduct any investigation. All rise, please.
Jurors are exiting.
Okay, Mr. Lawler, will a 15-minute break be sufficient for you to get set up?
I don't need 10.
Okay, well, we'll take a 15-minute break just in case.
15 minutes.
Okay, thank you.